Chief Justice, may it please the court. My name is Amy Kepes. I am with the Public Defender's Office. I represent the respondent, Jeffrey Anderson. The question before the court today is whether the respondent, Jeffrey Anderson, who is no longer a sexually violent predator, can be returned to the Civil Commitment Unit for sex offenders for a revocation of his release with supervision because of a rule violation. If that can be done without a finding that he is once again likely to reoffend because of a mental abnormality. And that didn't happen here. Mr. Anderson was out on release with supervision. He remains a committed person under the statute 229A, but he is not confined, and he is not a sexually violent predator, and that remains today. Mr. Anderson is living at Counsel, which I will continue to call it the Civil Commitment Unit for Sex Offenders, where committed sexually violent predators reside because they have a mental abnormality which makes him likely to reoffend if not confined to a secure facility. And yet Mr. Anderson is the only individual living there who is no longer likely to reoffend. This happened after Mr. Anderson gained the right to a final review hearing. That happened in February of 2015. It was a hearing before a jury, and at the end of that trial, the jury made findings of fact. The burden was on the state at the time, and the state had to prove one of two things. The state had to prove beyond a reasonable doubt, and the question was posed to the jury. Did the state prove by evidence beyond a reasonable doubt that the respondent's mental abnormality remains such that he is likely to engage in predatory acts constituting sexually violent offenses if discharged? The jury said no. The jury responded that the state failed to meet its burden in that regard. On the second question, did the state prove by evidence beyond a reasonable doubt that the respondent is not suitable for placement in a transitional release program? To that, the jury responded yes, that the state did prove that Mr. Anderson was not suitable for transitional release.
Let me try and move the discussion a little bit, at least to what I see as kind of the key question in the case. It does seem that Mr. Anderson ended up where he was through, in effect, a stipulation, where he ended up between the parties at Fort Des Moines. And then he violated the terms by engaging in what was at least arguably a non-consensual sexual act with another inmate off premises who was much younger than him, et cetera, and so forth. Under the statute, he can be sent back to a secure facility, right?
Yes.
So the only issue is it unconstitutional, given the set of facts that I've outlined, for him to be returned to the secure facility? And maybe he needs to get another hearing at some point in time, which I think he probably would. But is that really why is that set of facts unconstitutional?
Because under Matlock, once he is released with supervision, he no longer has a mental abnormality that makes him likely to reoffend. In order to confine him, he must have both a mental abnormality and the requisite dangerousness. The nexus is the mental abnormality and the likelihood, being more likely than not to reoffend if not confined to a secure facility. So this is a gentleman who, based on the court's ruling, a jury verdict in February of the same year, was found to no longer have a mental abnormality.
So from a practical standpoint, you know, I sort of analogize these to parole revocations in the criminal context. I know we're not in that, we're in a civil, on the civil side. But as a practical matter, looking at just the practical realities, what is to be the consequence for a violation of the rules of supervision?
And let me,
I mean, are you suggesting you have to go back and have a new court proceeding to put on evidence of mental abnormality and dangerousness in order to get him back into the program?
let me answer both of these issues. With respect to the violations that led us here, on a Friday night, the application for revocation was filed stating that Jeff Anderson assaulted another individual who was at the fort. This is a correctionals facility, a release facility, where many men reside, and one of the rules of the fort is that these individuals can't have sex with each other. It's just, it becomes untenable, it creates problems, it's just not allowed. By Monday morning, the amended application for revocation made it clear that there was not an allegation of assault here. This was consensual sex.
I don't know about that. I mean, it sounded like when this other individual who was 18 years old first reported the incident, when he was kind of felt safe and he was off-site, he said that it was coerced, that it was forced on him. And then later he's back in the premises, presumably with your client and other inmates, and he recants the story. I mean, this could be a domestic abuse kind of situation where the accuser recants because he or she is afraid of the perpetrator.
I understand the court's concern, but this is a much different situation than that. This was a one-time sexual encounter. These individuals were not in a relationship. The rules at the facility made it clear to this 18 or 19-year-old man that if he had sex with another individual while he was at the facility, consensual sex, he could go to prison. He had an absolute motive to tell a story that he was assaulted, taking the responsibility off of him. What happened is when the police questioned him, it took very little time for him to go from saying this was an assault to admitting that, yes, there was no way he could hold down both my hands and unzip my pants, and it wasn't an assault. It was consensual. I lied. I didn't want to go back to prison. So what we had here was a non-criminal, non-assaultive, but sexual incident, which was, in fact, a rule violation.
But counsel, on a credibility issue as to what happened between those two, Judge Gamble heard the testimony of your client. Shouldn't we give weight to his credibility determination? He's better able to judge that credibility than we are, right?
I think this case can stand perfectly well without relying on the credibility of Mr. Anderson. The second individual did not come in and testify. He did not allege that he was assaulted. The final presentation by the court was that this was a consensual sex act. It was a violation of the rules, and it required revocation. But it's an important question as to whether the state proved beyond a reasonable doubt that there was, well, and we don't even have that standard yet.
Could you come back to my question?
Absolutely. When we have let somebody out because they are no longer more likely than not to reoffend because of a mental abnormality, they are released. They are still committed, but they are not confined. Yes, to confine them again to a secure facility, we must once again find that they have a mental abnormality, which Mr. Anderson still does, and that mental abnormality makes him more likely than not to reoffend. And I do believe that we would need that whole fact-finding hearing again.
But, you know, if you read Hendricks and you read Garrett, which are the United States Supreme Court in our cases, I think you're probably right that you cannot keep somebody at CUSO unless there's a mental abnormality, excuse me, and they're more likely than not to reoffend. The statute has this provision, and I guess you're saying it's probably not constitutional that when you break the rules, they can't put you back in there, but can't they put you somewhere pending another hearing whether or not you meet the Hendricks-Guerin qualifications, without just saying, well, you could stay where you are?
These allegations came up and were filed October 16th and 19th of 2015. On October 22nd, the order was issued that Mr. Anderson would be taken into custody, and he would live at the the CUSO unit.
Wouldn't this be cured, though, if they took him in custody and maybe put him in the Polk County Jail or somewhere, the local county jail, pending a hearing on whether or not he meets the Guerin-Hendricks requirements?
I don't see a problem with that, so long as there is a right to a hearing in a speedy time frame, which is how these matters under 229A are handled. And if it continued that way, I don't see that that would be an issue.
Well, can they put him in CUSO pending the hearing?
CUSO is designed to be a treatment facility for individuals with a likelihood of reoffending because of a mental abnormality. It is also the site of the opposing party in this matter.
Well, you know
Counsel,
what?
you know, what we're dealing with here, of course, is a liberty interest. And I think I just heard you say it would be okay to put him in jail, but not to put him back at CUSO. Did I hear you say that correctly?
And
if so, why?
well, what I'm thinking of is the fact that when somebody is petitioned for civil commitment, and this lays out where I'm probably wrong, but when somebody is petitioned for civil commitment, the state looks at them initially on paper, determines under the multidisciplinary team and what they have available to them that this person, by a preponderance of the evidence, may meet criteria. They are then housed at Newton facility at the Safekeeper's House, and maybe that would be a option.
That's what I was getting at, because, you know, when someone's committed originally, they're not released from Anamosa or Fort Madison to go out in the world until they have their hearing under Hendricks and Guerin that's required. So it seems to me that the statute, if you're right, may be deficient in not requiring that hearing before you go back to CUSO, but for the rule violation, and Fort Des Moines doesn't want him anymore, he can be held somewhere, and you say Newton, I don't know the particulars, and the state has to afford him a speeding hearing on a civil commitment, because it's not a criminal case.
Right, right. And it was probably short-sighted to say, sure, put him in jail. So, but there should be an appropriate place where he can be while it is sussed out whether he now has a mental abnormality that makes him likely again.
All right, he did get a hearing, right? He got a pretty elaborate hearing in front of Judge Gamble.
He did.
And Judge Gamble didn't simply decide the question of whether there had been a rule violation such that he, had violated the terms of Fort Des Moines. Judge Gamble also decided whether he needed to be back at CUSO and concluded he did. So why isn't that enough?
It is not that it's not enough. It is that it was a misinterpretation of Matlock. And it was a misunderstanding of the transitional release program and how this whole statute works. 229A 9B4 sets out that the state has to prove by a preponderance of the evidence that a rule violation occurred. After that, the question is, what does the court do about that rule violation? Options are send him back to release with supervision, send him to release without supervision, house him in transition, or house him in the secure side of CUSO. What the court did in this case, and the problem with that statute is it lacks a burden of proof, and unless you read it in the context of 229A9, which requires that all of these proceedings as to commitment and I believe treatment comply with constitutional requirements. If you don't read it along with that section, then 229A 9B5 is unconstitutional because it allows a court who found by a preponderance of the evidence a rule violation to, without a finding of likelihood to reoffend, to put him back in CUSO. And without likelihood of dangerousness and the mental abnormality, under Matlock, it is the surrogate for punishment. And that is the problem we have here. Additionally, what becomes clear when Judge Gamble's order of, I believe, February 22nd and March 27th are read, those are in 2015, and it is an effort to try and suss out what does this jury verdict mean and what can we do with this guy now that we have that he can't go to transition, but he can be discharged in the jury's opinion. And at that time, and what becomes clear after Dr. Tapman's testimony, is that Judge Gamble is under the notion that transitional release is a necessary and important part of treatment before a sexually violent predator can graduate the program and get out. It is simply not true. What has to happen is when a person is committed as a sexually violent predator, they are more likely than not to reoffend because of a mental abnormality, and they must be housed in a secure facility until they no longer are. If that individual, 3 years later, having had no treatment, is suddenly more likely than not to reoffend, he gets out. If the person goes through transition and is in there for 8 years, and they still are more likely than not to reoffend, they don't get out. So Dr. Tapman's testimony that Mr. Anderson missed an important part of treatment is incorrect and violates Matlock. I see I'm out of time. I apologize.
Thank you. Ms. Kraemer.
May it please the court and counsel. Mr. Anderson agreed to release with supervision. There was a conflict and the jury verdict was confusing, and there was an entire hearing directed at the Matlock opinion and whether or not release with supervision was appropriate, and he agreed. He stipulated to release with supervision. It's a package deal. It's not just release, it's also the supervision component. There are rules, and there needs to be a consequence if the rules are not complied with. Here, the rule violation was a significant one, even if we're conceding.
How can he be held at CUSO if, under Guerin and Hendricks, if he does not have a mental disability and it's more likely than not to reoffend and have a determination, which I think a jury's, and he's entitled to have a jury make that determination.
The problem is timing. The statute on revocation gives 5 days before we have to be prepared. And Dr. Tapman, as far as resources, is about as good as it gets for the state to have access to a licensed PhD level psychologist who does risk assessment. But he testified that he was not able to do the kind of evaluation that would be required to answer that
So the
question.
state didn't make, and in fact, Judge Gamble found that in his order. He says, Dr. Tapman could not say whether Mr. Anderson was more likely than not to reoffend. And Judge Gamble made that finding. So how can you constitutionally put him back into the situation under Guerin and CUSO, under Guerin and Hendricks? And I understand the statute has all these things, but the statute's pretty bad. I mean, when you read it, because the front end doesn't match the back end, going in doesn't, and I see you're sort of smiling and you know what I'm talking about. But the question is, the Constitution requires 2 things to be in there. And those 2 things aren't there, under this record even, because Judge Gamble didn't even find it.
Mr. Anderson has conceded he still has the mental abnormality, which is the requirement under Matlock. Matlock found the release with supervision program to be constitutional. Dr. Tapman did testify that this conduct by Mr. Anderson increased his risk. He was not able to say whether that was more likely than not. And again, we have a timing issue. Mr. Anderson will have a whole nother full evaluation, full court hearing, as the annual review process kicks up again. So it's not like he's going to be at CUSO indefinitely. His due process kicks in again at this next hearing.
It seemed under Guerin and Hendricks, 1 day violates due process, whether he has a hearing or not. I mean, that was the whole linchpin of the United States Supreme Court decision, that you have to be more likely than not to reoffend in order to put someone in this treatment.
The statute also treats people who have already been adjudicated a sexually violent predator differently than people who have not ever been adjudicated. Once you are adjudicated at one point, there is a presumption. Here, the statute treats a person differently if they are in release with supervision, having been adjudicated. And
Let's take a hypothetical. Let's say he was at Counsel and prior, 6 months between annual reviews, he's no longer, as a point of fact, dangerous. He doesn't actually get out until there's an annual review, potentially. So he's going to be detained 6 months. This is kind of comparable to that, isn't it?
he can petition for discharge at any time.
But, and,
If he has an expert opinion that says he's no longer dangerous, people do. They do petition for discharge.
and didn't we say in Matlock also that you can have ongoing restraints on liberty even after you get that determination that you're no longer dangerous, or more likely, I guess more to be specific, more likely than not to commit further sexually violent acts. If you, even after you get that determination, you can have further restrictions on liberty so long as they're treatment related and not punitive, right?
Correct. And this is treatment related. This is a failure of his treatment. He has been through sex offender treatment, made a pretty bad call about a sexual issue. The victim was inappropriate. The fact that he's having sex in public is inappropriate. The fact that he's not disclosing it to his treatment group. These are all things that are helping sex offenders make better choices.
Well,
as they
true,
go into the world.
but isn't it, do you leave room for the possibility that the problem here is not the statute, but rather the limitations of the supervision program? I mean, there were other options here other than sending him back to Counsel, right? I mean, there could have been consequences for him within the treatment program. And it's not like he committed some new crime that we might think more reasonably could land him back in Counsel. I mean, isn't this, address that. Isn't this a problem with the limitations of the treatment program rather than the statute?
That there aren't sufficient gradations to account for different conduct. They had given him, the record will show that he was given a thinking report for contact with another individual. They were fist bumping, and that was
On a
enough.
previous occasion.
Right, on a previous
They wrote him up
occasion.
for fist bumping, right?
Correct. So that would be an example of a treatment approach and a consequence less severe than revocation. Here, the conduct was sufficiently severe that they were not comfortable keeping him in the fort for any length of time. And even the period of time between the initial court filing and when we got the court order to revoke him, the Department of Correctional Services was not at all comfortable supervising him given his conduct. It does create an issue. The 5 days, the state cannot get the evaluation in that amount of time that would be needed to prove up the more likely than not. But it can do it within the year, and the statute brings the annual right of review again once the person's recommitted to
But
consent.
under Madlock, transitional program is not released with supervision. I mean, we made that clear.
Right, and I'm not contesting, it's confinement. Transitional release is confinement. It's more graduated. They still have access to the community, but they sleep at Counsel.
Involved confinement too. He was at Fort Des Moines, correct?
He was, and he was put on lockdown once this incident occurred, which meant he no longer was given passes out into the community.
Well, it just seems, I mean, I'm struggling a little bit with the notion that somebody might have a full year of confinement in Cusco, conceivably, under your position, I think, without having number one, without being more likely to reoffend and without having a hearing. I mean, it sounds like you get if you violate a rule, if you will, you end up with a year of incarceration, even though you don't have an opportunity to be heard on one of the fundamental questions until a year down the line. I mean, it strikes me as a year of what amounts to incarceration without qualifying under the statute.
Well, there was a full hearing. We had a full hearing. There was
And you
expert
didn't meet,
testimony.
and you didn't meet one of the criteria, I think, right?
Not under the revocation criteria. If the court adopts that the revocation criteria do not need to satisfy the full commitment criteria, and I believe in supplemental authorities I cited to an Arizona opinion of that nature, then it is sufficient.
I have a question going all the way back to the original trial on the final hearing. What do you make of the requirement that, you know, the state has the burden of proving either of the following? First of all, that they meet the qualifications of a mental abnormality, which I think we all agree he still has the mental abnormality, he just doesn't meet the second prong, that the jury didn't find that he was going to have more likely to commit a sexually violent offense if discharged. But then how do you read the second portion when the state did in fact prove that he is not suitable for placement at the transitional release program pursuant to the code? How do you read that finding of the court? And I know the district court struggled with this, and everyone struggled with this. I can only tell you what I see that as being is that maybe he, even under that finding, he could still be actually confined at CUSO.
If that were yes, to the extent those two opinions are inconsistent, the second opinion would still require confinement at CUSO, and the factors for transitional release still require that the person has a mental abnormality and is at a high likelihood to reoffend.
And so I think, you know, and I'm not questioning Judge Gamble, but I think even at the original outset, we had all these options available except for transitional living, because the determination had already been made, you know, the 9 or 10 factors that fall under the transitional living. He clearly had not achieved or demonstrated significant insights in his sex offending cycle, the whole 9 or 10 factors that are there. So isn't a likely result of this could have been sending him right back to CUSO anyway?
I'm not sure I'm following. I'm sorry.
Because the state proved either of those. The state's burden of proof is only to
met.
prove either of those factors. Either the first one where he was originally committed, and certainly was, and met those requirements, but secondly, he hadn't reached that level, the jury found he hadn't reached that level to even get him into phase 5, which is transitional release. Isn't that what the fair reading of the jury's verdict is?
If I'm understanding, Your Honor, given the two inconsistent verdicts, the second verdict would suggest that the state did meet its burden, that he was more likely than not to sexually reoffend. And so there was never a finding that he was not a sexually violent predator anymore.
Well, I guess what I'm saying is the state did prove that he wasn't even qualified at that point to go into transitional release.
Correct.
Which means he hasn't even reached phase 5 of his treatment plan. The jury found he wasn't even at that point yet, which would get you to release, but then by stipulation, everybody agreed that he could be released with all these conditions, and everybody agreed to them, correct?
Correct, that is what happened.
Then, the statute says pretty darn clearly to me anyway, that once the state has proven by a preponderance of the evidence that he has in fact violated the rules, then the district court has the discretion to do any one of those things, listen to recommendations, have a full hearing, and decide where he ought to be placed. And isn't that what happened here?
That's exactly what happened. Mr. Anderson had an opportunity to present his case. He called expert witnesses. We cross-examined. Dr. Tapman did try to testify to Dr. Salter's opinion from the jury trial that he remained more likely than not to engage in sexually dangerous offenses, and Judge Gamble wouldn't let that discussion in. So he was left with his evaluation, his risk assessments, which showed that Mr. Anderson's risk was greater now, having done these offenses, than at the time of the jury trial. If there are no further questions, I'll concede my time.
Thank you, Ms. Kraemer. Ms. Kepes.
Justice Zager, with respect to your line of questioning, let me point out that from my reading of it, that jury verdict is not inconsistent with itself. It is entirely possible that the state failed to prove that Mr. Anderson's mental abnormality remains such that it makes him likely to reoffend. And therefore, he's no longer a sexually violent predator. It is also possible that he fails to meet the criteria for transitional release. One of those criteria is that it is in the best interest of the individual that he go to transitional release. We did not do special interrogatories laying out those 10 criteria, and so we are left to wonder why the jury felt he was not appropriate. There was testimony from both experts. At least the respondent's expert testified that with respect to those 10 criteria, he was appropriate for transition. So I don't believe that we can determine from that verdict.
Well, but the jury disagreed. You know, they have the right to either credit or disregard any expert's testimony. They obviously disregarded the expert testimony by Mr. Anderson in this case, and they said he doesn't meet these 10 criteria, whatever they are, whether he meets 2 or 5, and oftentimes in these reports, they'll meet 4 or 5 out of 10, but not all 10 of them.
But we
and some of
can't-
them are easy.
Yes.
I'll agree to register as a sex offender. Some of them are not so easy. So we don't really have to worry about what they did or didn't decide to do. We know that they said he hasn't met those qualifications. He hasn't met those treatment requirements to even get into transitional. Would you disagree with that?
I would add this. We can't say why they said he's inappropriate for transitional release. We also can't assume that it says anything about his dangerousness. We cannot assume that it means that he's still a high likelihood of reoffending.
Yeah, I agree. I think they're measuring 2 different things, and they're asking 2 different factors. But what they are saying here is, from a treatment standpoint, and from hearing all the expert testimony here, he doesn't meet phase 5. He doesn't meet the treatment goals of going into phase 5. And so, do you disagree that one of the possibilities as a result of this jury's verdict could be that he could have been sent back to confinement at Counsel, just a straight secure facility?
I absolutely disagree. The court's analysis of that and sort of rumination on that is in the record in the February and the March rulings. Having grappled with this statute for years, we have wondered why are there these 10 specific criteria for transitional release and just this one vague criteria for discharge, when discharge is what people really want. That we have expected it would come to pass, that somebody would be inappropriate for transition but appropriate for a ruling of discharge which would lead them to release with supervision.
Well, what do you think that second, the jury's finding, what do you think that means?
I think it means that he doesn't go to transition because it won't benefit him. I think it also means that he is no longer more likely than not to reoffend. If he gets a ruling that says the state failed to prove that he is still more likely than not to reoffend, I think transition becomes irrelevant unless he wants transition as his way of moving back out into the community. After a jury finds discharge is appropriate, the court can put him on release with supervision. And if he and the state decide that transition would be a good way of doing that, then that would be a good thing. But in practice, people are in transition for 7, 8, 9 years. They break a rule, they have a hearing. If he violated the rule, he goes back. It is from one committed area to another committed situation. Here we have release, we have liberty. We can't just have a rule violation that takes him from liberty to confinement without that nexus.
Well, I guess, why can't we? I mean, it clearly provides in the statute, and everyone knows what the statute said. We're going to release you with these terms and conditions, and everybody stipulated to it, so it's really not a Matlock situation where we said you have to consider all these things, and Matlock may have been overly broad in all the terms and conditions of your supervised release. But why can't here, the statute specifically says, if the state proves by a preponderance of the evidence you violated your terms and conditions of release, then I, as the district court judge, have the discretion, listening to a full hearing, full due process hearing, notice, opportunity to be heard, and testimony of experts and, Mr. Anderson himself, then the court has the discretion to do it, including transitional release. Doesn't the statute specifically say that?
The statute does. But if you read the broader statute as a whole, You can't confine someone at CUSO unless they are more likely than not to reoffend because of a mental abnormality. If you read 229A9, these matters must be handled constitutionally. If you take away the dangerousness, we now have a surrogate for punishment. And that is where we are in this. This is the first case that we've had that deals with this issue, and I wasn't able to find others because it does take people so long to work through the program and get to this point. So we're now at the point where these matters are coming up. I do think that if you don't read 229A.9B5 to require a mental abnormality which makes him likely to reoffend, that you can't just confine him. The state takes issue with the fist bump, which is it's like a handshake or a high five, and a hand on the shoulder, and couples that with consensual sex. These are rule violations. These aren't violations of an individual. This was not a sexual assault. This is all being presented as part of his, I'm over time, part of his pattern. This was not a pattern that led to sex offending. This is a man living imperfectly in society, and it is not more likely than not to reoffend. I would ask that the court remand the case with instructions to return Mr. Anderson to release with supervision and with some sort of therapeutic counseling to handle how we got into the situation and how he dealt with the situation so it doesn't happen again. Thank you.
Thank you as well, Ms. Kepes. The case of in-raid the detention of Jeffrey Anderson is now then submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.